everyone, welcome to Sunya IAS. Guys, in today's class, we are going to talk about more high value topics which will help you score more in your prelims examination. Now, today we will talk about certain important articles and a lot of dimensions around them. Okay. Now, why are these topics or articles important, or we call them high yielding? Some of these articles are asked by UPSC again and again on a repetitive basis because they form, the fundamental pillar of the constitution. The concepts which are ingrained in these are very important. They are pivotal. Okay, and some articles have been in news recently. That is why we are going to discuss them. So two things, right? But before we start, let me tell you, if you want to understand polity from a conceptual level, if you want to take your polity subjects knowledge to UPSC level, there is a crash course available wherein in 20 to 25 hours we have explained the entire syllabus in a very crisp manner. Okay, also this book here contains around 150 pages and it is consolidated from sources like NIOS material from NCERTs and our standard reference book, Indian Constitution by Indian Polity by M. Lakshmikant sir. So what is the benefit of this? These are high yielding revision notes. Just 150 pages means that you can revise your entire syllabus in a day or two. Okay, more the number of revisions, more is the probability and possibility of you to recalling that concept, recalling that information in your examination, which will lead to you taking the correct option. Now let's get started, and the first article that we are going to talk about is very important. Okay, it is article number 14. Now when I talk about article number 14, it is enshrined in part 3 of the Indian Constitution. Also, it is a part of fundamental rights. The rights enshrined here are fundamental. They are justicable. It means that if they are infringed, you can go to a court of law and ask for remedy. Okay. Now, when I talk about Article 14, then from Article 14 to Article 18, right to equality is guaranteed. Okay. Now, what is equality? Why is it so important? In any democracy, equality is one of the magnificent cornerstones, and so it is for the Indian democracy as well. Also, understand one thing, that equality is a corollary or a precondition to rule of law as well. Okay, these things that I'm saying might appear in your examination as a statement. So whenever you're attending any online lecture or class or watching a video, please start making running notes, because our attention span in any online mode of education is lesser than the offline one. But if you make notes, then your attention will be here. And in this video, we are going to discuss a lot of things that you have not known about or heard about before, and it is going to be a value added high value topic class, high yielding topic class. Okay. So now when I talk about article number 14, we have to know that it is available to citizens and non-citizens as well, to both of them. Also, if we talk about article 14 and article 21, there is a term person. Now this term here is gender neutral. That is, what do you mean by gender neutral? It will also incorporate the third gender. Okay, so this is not just for men or women. So there can be a statement in your examination that article 14 and 21 are gender inclusive. So that statement will be then very correct. Also, we have to understand one thing before we get into the details. What are fundamental rights basically? Fundamental rights place restriction on the powers of the state so that the citizens or the individuals can have a sphere for growth. in terms of material, intellectual, spiritual, physical, all sort of growth. So this Article 14 places a limitation on both legislative and the administrative organ. Okay, legislative plus administrative organ. It is putting a limitation on the actions of these both. Okay, now when we look at it from a point of view, so what does the text of Article 14 say? Now we have understood the characteristics of Article 14, the importance of Article 14. So what does the text in the Constitution say? It talks about equality before law and equal protection of laws. It has two things. Now these are two different concepts. So equality before law, this concept has been taken from the British Constitution. Equality before law and British. A lot of students have a hard time remembering which phrase was taken from where. So before and link it with Britain. You should take help of such mnemonics, wherein by looking at a thing, you will instantly remember the contents of it. Okay. Now, what does it mean? It means that everyone will be equal before law, be it a rich person or poor person. So there will be no economic distinction, irrespective of their caste, creed, anything, any parameter. Nothing will be considered. Only citizens and non-citizens, even they will be considered equal, because this is applicable to both. Okay, equal treatment for all persons, and there shall not be any privilege for any particular person, and no person shall be above the law. Very simple. So this concept puts everyone on a same pedestal. It is negative. Why is it negative? Because it is putting everyone on the same pedestal, irrespective of their conditions. So in compared to that, when we look at this thing, okay, equal protection of laws, this is derived from the American Constitution, and it says that similar application of same laws to all persons who are similarly situated, equal treatment under equal circumstances, both in the privileges confirmed and liabilities imposed by the laws. So it is saying that if two people are in a different situation, they can be treated differently. Okay, so can I say one thing? That here, this article, okay, this article enables class legislation, right? But in the essence of it, it also prohibits class legislation. It says that the classification, okay, it states that the classification should be based on rational differentiation. What does it say? The classification should be based on rational differentiation. The word used in your standard reference book is intelligible differentia. Now it means that when you are treating likes alike and unlikes unlikely, then what is the basis on which you are differentiating people? So now let's step ahead and think what could be the difference. Here we could treat people who are from the weaker section of the society differently. Can we do that? Yes, we can see that in Article 15 and 16, right? So in a way, Article 15 and 16 are a part of Article 14. They have evolved from Article 14, because here we are making special provision for people. 15 says that we have to, there shall be no discrimination on grounds of. There are 5 grounds mentioned: race, caste, religion, sex, and place of birth. and it also enables the state to make separate laws for women, children, social and economically backward classes, scheduled caste people and scheduled tribes. 16 talks about equality of opportunity in public appointment, and here also we can see, what can we see? These kind of reservation. So this is the manifestation, the subparts are a manifestation of Article 14. Okay, I'm making it as easy and as lucid as it gets. Okay, now if we talk furthermore, then Article 14, the basic concept resonates with Article 7 of UN Human Rights Declaration. Okay, so our fundamental rights chapter, है ना, and we are comparing this one as well, because you don't know, UPSC might put a statement like this. Okay, now here Article 14 or equality is a basic feature or one of the basic structures of the Indian Constitution. In which case did the Supreme Court pass that judgment? This is one homework and I need all of you to write it down in the comments. We have been seeing a trend in UPSC that they are putting different committees and cases that we don't read normally as a statement, and that is where we are getting lost. Okay, now there's another thing that I would want to discuss with you guys. You know about compassionate employment. If there's a government employee, that person dies out of some uncertainties, usually one of the member of their family is given a job. It is called compassionate appointment. Now, compassionate appointment is not a right, and the principle of equality cannot be applied to it. Rather, the principle that the state wants to look after that employee and wants to ensure that the family is not facing any turmoil is applied. Also, when we talk about the other articles, okay, if there are no rules or anything mentioned, then the general principles of Article 14 will be applicable. You're talking about Article 15 to 18 here. Okay, very simple. Also, there are no steadfast laws or rules for application of Article 14 when you go to a court. Every case is looked upon individually. Okay. This is it about article number 14, and let's go to the next article, which is another important article, article number 19. Now this also belongs to part 3 of the Indian Constitution, is a part of the fundamental rights, and article number 19 to 22, right to freedom. Okay, these articles, they ensure certain amount of freedom to an individual. Now this here is going to be applicable, the 19 article, only citizens. Now a lot of students cannot remember that what articles are applicable to citizens, non-citizens and only citizens. So 15, 16, 19, 29, 30. These are applicable only to citizens. Rest other fundamental rights will be available to non-citizens as well. Okay, now when we talk about article number 19, it is not just a fundamental right but also promotes certain democratic values. Okay, it is a basic right, a human right, a fundamental right that also in a way talks about uniting the nation. Yes, the characteristics. What are the rights that you're getting? Freedom of speech and expression, assemble peacefully and without arms, reside and settle in any part of the territory. So here You will see oneness throughout the country. Also, move freely throughout the territory of India. Form associations or unions. And assemble peacefully. Okay, we have written it there. But here we have the text. Now, guys, tell me one thing. Is right to form political parties a fundamental right? Yes, it is a fundamental right. ठीक है? Here, right to form political parties, companies and organizations, also cooperative societies, is a part of the fundamental rights, and a right to not join any association is also a fundamental right under this article. Now we have all studied a lot of content on Article 19 and all, you all are pros when it comes to the nitty-gritties of it. But let us understand one more thing. Okay, that when Article 19, okay, when your Article 19 is infringed and you go to the court of law, you can only go and file a petition if it is infringed by the state. Article 19 is not available against private citizens. Okay, very important. है ना? Now let's go ahead. Now we will talk about article number 21. What does it say? It says that protection of life and liberty. This was the original text, and this is one article which is most expanded by the courts, and lot of new rights have been added in it. The expansion of this right started with the Gopalan case, and this case brought about a better procedure and better rights for those under trials, even better than enshrined in Article 22. Now when we talk about article number 21, article number 14 and 21 read together forms the heart of part 3 of the Constitution. है ना? Very simple. Now as you can see, there are a few rights written here, but the important part is that when the Supreme Court is looking at this article 21 and expanding the interpretation, we have to consider a couple of things. Okay, one is due process of law, and the other is procedure established by law. Now this is the text written in our Constitution, procedure established by law. It means that while checking the validity of any act enacted by the Parliament, the Supreme Court, okay, will just look at if the authority which has enacted the law is competent enough. Does it have the power or the authority to enact a particular law, or the procedure by which the law is formed? The court will not look at any other aspects, but the due process of law doctrine comes from the Constitution of USA, that is America, and this one also talks about the impact of a law on a person's life. So this is a wider concept, and the Supreme Court has held that the phrase procedure established by law has to be interpreted with the value of due process of law whenever the court is examining the validity of any fundamental right. Very simple and plain. Okay, we are not going to expand it further, but there it is the most expanded right. It's like you will have a right to pollution free environment, right to sleep, okay, and a lot of other rights are added to it via various Supreme Court judgments. So where article 19 talks about freedom to move around freely anywhere in the country, article 21 talks about freedom to go abroad. So 19 talks about mobility inside the country, and 21 talks about mobility outside the country. This is also one point that we all should remember in our minds. Okay. Now we are going to look at article number 38, which is a part of Part 4 of the Indian Constitution, which has the DPSPs. We borrowed the DPSPs from the Irish Constitution. Okay, when the Indian Constitution was made, it was a laissez-faire era. Now, what is a laissez-faire era? It's an era wherein the government would just restrict itself to maintaining law and order inside the country and not get involved in the market or the economic processes. But when our framers of the Constitution were making this wonderful Constitution, they thought that India is a country with lot of social and economic inequalities, and to safeguard the weaker section, we will have to put something that will look after these people. So this is a part which is ensuring justice to the people residing in India. Now part 4, the DPSPs are not justicable, but they are pivotal whenever any law is formulated, or whenever the Supreme Court is looking at the validity of any law made. Okay. Now Article 38 is always read closely with Article 14. Now why? And you have to understand the difference between fundamental rights and DPSPs as well. Fundamental rights are individualistic. It will give every individual their own right, whereas DPSPs are collective. Okay, they will talk about establishing a welfare state. They will talk about uplifting the weaker section as a whole and not individual rights. So the fundamental rights and DPSPs are always contradicting each other. And that is why Article 38 is usually read with Article number 14. Now why? Article number 38 reads, promote the welfare of the people by securing and protecting a social order by ensuring social, economic and political justice. Okay, it also talks about minimizing inequalities of income, status, facilities and opportunities. So here we are empowering the weaker section using Article 38, whereas Article number 14 is talking about treating everyone equally. But then Article number 14, the second component, the positive concept, talks about treating unequals unequally. So both of them are usually read together by the courts. Now let us understand an example. How are they read together? Okay. The taxation. Let's look at the taxation. The income tax. How is our income tax? It's a progressive system. What do we mean by that? People with higher income are taxed differently on a higher slab, and people with low income are taxed at a lower slab. So Article number 14, it talks about treating equals equally and unequals unequally. And by collecting more tax from people who earn more, what are we trying to do? We are trying to minimize the inequalities. Understood? This is a very simple example and everyone should have understood by now. Now Article 38 is also read with Article 19 and 21. How? Article 19 talks about freedom to move about anywhere in the country. 21 talks about right to life and liberty. It also includes right to have some sort of economic opportunities. So when there was a petition filed in the High Court about construction of roads in hilly areas which will enable people to move freely, also enable the people living in hilly areas to actively participate in economic activities. And 38, minimizing inequalities in income, status, facilities, opportunities. You getting my point? So whenever these kind of things are asked in UPSC, don't get confused. Think logically in the lines of what we are talking right now, and you will be able to reach the answer very easily. But for that you will have to start thinking like this, and for that you will have to watch all the lectures that Sunya IAS comes up with. Now let's look at article number 39. Now there are a lot of components to article 39. Let's start with a few. The protection of the strength and health of workers. So here by all these articles we are trying to establish a welfare state, wherein we are looking out for workers, that if the workers will stay healthy and strong, they will be able to earn their livelihood. So it is the obligation on the companies that employ workers to look after their wealth and health and being. Childhood and youth shall not be exploited. Okay, now children and youth. Then right to an adequate means of livelihood to all citizens. Now these are non-justicable, means that if you don't have an adequate means of livelihood, you cannot go to the court and invoke Article 32 and ask for a remedy that is written in the Constitution, but I am still not getting my right. Okay, so it will enable the government to make certain acts, laws, provisions by which the government can provide means of livelihood to citizens. Say for example the Manrega scheme, है ना? It offers 100 days of employment to people living in rural areas. The ownership and control of material resources shall be organized in a manner to serve the common good. You will have seen many examples here. Lot of silk mills or any other sort of textile mills which were running in a loss or which were not doing good were acquired by the government. So here the government can acquire them, and that will be for common good. The state shall avoid concentration of wealth in a few hands. Equal pay for equal work for both men and women. Now this article, what it says, it is not absolute, it is substantive. Okay, it has to be interpreted differently for every person, and there has to be laws enacted, legislation enacted by the legislature for implementation of all these things. Whereas for article 14 and 19 and 21, okay, if there is any law which is enacted which infringes it, then we can go to the Supreme Court under Article 32 and ask for a remedy. So the fundamental rights, okay, they put a negative obligation on the state. They limit the action of the state. Whereas the BPSPs, they are positive in nature, as they enable the state to do a lot of activities for the citizens. Okay, let us go ahead and look at some new articles now. Now we are going to talk about Article 161. This article talks about the pardoning powers of the governor. They are similar to Article 72, which talks about the pardoning power of the president है ना, pardoning power of the president. But why is this too much in news? Okay, the governor has the power to grant pardon, reprieves, respite, remission, punishment, or to suspend, remit, commute the sentence. There is a slight difference between the powers of the president and the governor. But recently the governor's power has been too much in news. Article 72 and 161 are not discretionary. The governor and the president will have to act on the aid and advice of the Council of Ministers. Also, recently, there's one difference. The president can pardon death sentences, whereas the governor cannot constitutionally. The president has the power to pardon even the sentences issued by a military court, okay, but the governor does not have such powers. But in a recent judgment, the governor has been given powers to pardon a death sentence. But if it is asked constitutionally, you know what the answer is now. Also, in this case, Maruram case, it was held that it is obligatory for the governor to put his or her signature on the same. Okay, now these powers are extraordinary powers given to the president and the governor, right? They will not be questioned in any court of law. If a person is in prison and he wants, to invoke any of these grants, any of this pleas, then that person will have to write to the president or the governor. That person does not have a right to audience. He cannot go and speak to the president or the governor. This person will just have the right to write a letter, and then the president will take his or her own time, or the governor, and then they will respond to it. Let us go ahead. Article number 200. Again, one of the articles regarding the powers of the governor. Now, here, this talks about the power of the governor when he gives assent to the bills. Okay, the veto power exercised by the governor. Now, whenever, what is a bill, guys? It's a proposed legislation. It is a proposed legislation. So, whenever the state legislature passes a bill, it goes to the governor. The governor then can do 4 things with it. First, it can give assent. It means that the bill has passed and the bill will now take the form of an act. Not to give the assent, okay, it withholds that no, I am not giving assent to the bill, this cannot become a law, I don't agree with it. The governor can return the particular bill for reconsideration, okay, or the governor reserves the bill for consideration of the president. Now, when this happens, there is no fixed time bound on the president to give his assent. Okay. Article number 200. It doesn't give the a definite time frame for the governor to respond to a bill. And in numerous cases, this has happened. One of the landmark case was the Tamil Nadu legislature passed a bill saying that the undergrad students of Tamil Nadu shall be exempted from the NEET examination. This bill was lying with the governor for a long time without any action. This is a different thing. We will study this in detail when we look at the cases separately. Let's not mix up things today. Okay. Now comes Article 246A. Now, what is Article 246A? Usually, when I teach in my classes, I tell the students to bundle up the articles. So, looking at an article, you can at least make out that it is one of the articles from the Center-State Relations chapter, and that too the legislative relations. So, Article 246 talks about when the Parliament can make laws. Okay. Now, there is the Schedule 7, which has 3 lists. The center, state wala list, and the concurrent list 1, 2 and 3. And there is a residuary list Okay, wherein the power to make laws lies with the union government. Now, what does Article 246A says? Article 246A says that both the parliament and the states have simultaneous power to legislate on anything that is to be done for the GST. Here, the parliament has exclusive power with respect to formulating laws for GST when the trade is between two different states. Okay, it says that recommendations of GST Council only have persuasive value and are not binding on center and states. Please remember, they are not binding because students are generally in a mindset that the recommendations will be binding if it's a GST Council. Okay, and the recommendations are a product of collaborative dialogue. So, who has the right to make the laws if interstate trade is connected? The parliament, and both of them, they have simultaneous power to make legislations. Now, one more thing, guys. When we talk about the concurrent list means that the state and the center, they both can make laws on a particular, subject mentioned in the list. Now, there are no entries in this list pertaining to any sort of taxation. Please remember this. In the concurrent list, there are no entries related to taxation. Very, very, very important. Now we are going to look at Article 300A. Now the Article 19 also provided for right to property. But by the 44th constitutional amendment, okay, it was made a constitutional right under Article 300A. Now, why are we talking about it today? We have been seeing a lot of demolition going around, by the state of the properties of private individuals. They might be constructed illegally or whatever. Now, it says that it requires the state to follow due procedure and authority of law to deprive a person of his or her private property. It also talks about providing compensation, but it is not expressly written, but it is implicitly written that compensation should be given to people when the state is acquiring their properties. Okay. Now, let's come to Article 361. What does it talk about? The president or the governor is not answerable to any court for the exercise of the powers and the duties. So, it is an exception to Article 14, right to equality. The president and the governor will not be treated equally, and also for whatever actions they are taking in the official capacity, they will not be questioned. No case can be instigated them. No arrest or imprisonment can be done. No criminal proceedings can be taken. But yes, civil proceedings, okay, can be against the president, government shall be instituted during the term after expiration of 2 months of notice. No criminal proceedings, no arrest, no imprisonment, but civil proceedings, yes, that can be done. Very simple. And we end today's class here. Do keep on looking for more such informative videos. Thank you very much. See you soon in the next class.